I'm joined by Pinky Anand, former ASG and someone who's worked with the Modi government. Appreciate your joining us, Pinky Anand. The basic charge against these three bills is that while it changes the name of the Indian Penal Code and Criminal Procedure Code, the name change suggests that you're dramatically changing the laws. In effect, actually, you've only tinkered with it. Most of the law is cut and paste. And worse still, it gives even more draconian powers to the police and the state, especially when it comes on issues like sedition and terrorism. Your take?
Well, whenever you amend a law, whenever you bring about a new law, whenever you change the law, some allegation or the other is always made of the kind that you've just espoused. So basically, it's difficult to say this. The point really of bringing a new law is that if you amend the law, it tends to have various possible contradictions, some ethos that you don't want to repeat. You want to translate the whole into an anti-colonial, not anti-colonial, but something which has lesser colonial reference, or removing that element from our textbooks so that we have our own laws. So the concept of amendment, as I said, is one concept, and the amendment of bringing in a new law, because all said and done, there have been dramatic changes. So the dramatic changes, for example, let's take forensics. Let's take IT evidence. Let's take investigation with that. And I'm not sure about this draconian part. In any case, this is always the position in criminal law, that you do need to give police powers. It's not as if you can't. Either you remove that, but that element is not possible to be removed. And what you are doing, for example, is safeguarding. So let's say electronic evidence. When you're permitting a device to take in electronic evidence, or you're allowing forensics, which incidentally we need desperately by now. Times have changed. We no longer have to really go around the whole way without dealing with forensics, and we have constantly been arguing for forensics into the system. So you are bringing in those elements, and possibly another way was, as you say, to do something else with amendment of the law. But amendment of laws also has its own constraints and limitations, which the new bills have sought to bypass, as well as change the complexion by making it something which goes away from the colonial history, and therefore the renaming of the acts, which is brought into focus. In fact, I find some of the changes are substantively extremely desirable.
Give me one example. Give me one example, Pinky Anand. Give me one example of a change that you find desirable.
As I said just now, forensics, investigation by electronic evidence, outright giving of bail, changing the complexion of terrorism to make it not anti-government but anti-country, which I'm sure there could be literally no opposition to. So there's no removing sedition as such from the textbook. In any case,
it hasn't removed sedition. You see, this is the ingenuity of these laws. You haven't removed sedition. You've actually brought in sedition plus. Many would say actually in the new definition, the government will have even more sweeping powers to arrest someone under sedition with much more severe penalties. Similarly, when it comes to police custody, limits on bail, expanded police custody for a duration within 60 to 90 days post-arrest, and limited relief in bail procedure. So how is this going to be?
No, I don't know what you mean by limited procedure. For example, let me just share with you, Rajdeep, when you talk about, for example, releasing a person who spent half his term of the offence in jail should be released on bail. That is a straightaway release that you have. You've had time limits put down on the various trial procedures. The idea has been to give speedier justice so that you can see the end of a trial rather than the prolonged trials that actually carry on. You can always find fault, as I said, on the part of the police having powers in cases of sedition, which is against the country, in cases of terrorism, which is against the country, by in fact making it stricter to the extent, or limited, not stricter, but limited in application in its own way, and not extending across service. You say that's become draconian. This argument doesn't seem to be that palatable at all.
No, but you don't think that these laws will eventually enhance discretionary powers of police? What we actually needed was police reform. Instead, the government has gone in for legal reform. That too, as I said, according to legal scholars, cosmetic, because 90 to 95% is very similar to the old law. You give it a new Indian name, doesn't make it a new law. But the point is, instead of withdrawing the discretionary powers of police and reforming the police, this could be misused by the police.
Radip, I'm sorry. I mean, much as we all talk about police reforms and limiting the powers of the police, I'm afraid how do you really achieve that accepting for safeguarding? So that's why I say forensic electronic evidence, that by itself limits to the extent that you have it supported by evidence, which is what you drastically need today. We've been living on a period of circumstantial evidence, about direct evidence. You have forensics, which will, when it is there, prove it conclusively. So, this whole hogwash about saying don't give police powers, police will have powers. That is the agency. Police reforms, yes, police reforms are required, but while they are pending, you can't say that the law doesn't require. So, these negative kind of arguments to say, no, do that first, then do this. This is not the manner in which things are done. However, what we did need into place is the acceptance of electronic evidence, forensics. These actually expedite procedures into a much speedier system that we are talking about today.
So when, for example, critics are suggesting that it will give arbitrary power to label even non-violent democratic action as terrorism, you already have UAPA. Now, clause 111.1 of the BNS IPC widens the definition, many believe, of terrorism, and it could include even a non-violent act or a mere expression of speech or writing. So these concerns, are they valid, particularly being expressed by human rights activists?
I'm afraid that there is a wide schism between human rights activists and terrorism. I mean, terrorism cannot be condoned at any cost, in whichever manner it comes across, and that's my clear view. I don't even think that this constant criticism or critique of terrorism is an activity which I don't think deserves much defense, much as human rights activists may want to do so. So I have my fundamentals rather clear on that point.
What about the erosion of privacy rights with increased authority to seize digital devices as evidence? You mentioned that you believe that it is important to have forensics as evidence. There are those who believe that this could be a violation of privacy rights if my mobile phone, for example, is seized and used as evidence.
Rajdeep, again, I think we have to understand the fundamentals of fundamental rights. When you are having two possibly conflicting fundamental rights, there has to be a balance between the two. And the balance doesn't mean that privacy wins on all counts. If it is a question of an offense, if it's a question of a criminal action, there is no question of the privacy being intruded. That it doesn't work in that fashion. Privacy has to give way to concerns of a higher order. For example, security, health, like COVID, for example, it was said that you couldn't have an app which went into whether you had COVID or not, but you could and you should. You cannot bypass these procedures for the sake of this count of privacy. If somebody is going to commit an offense and the mobile phone actually has evidence of that, and that is seized, where's the question of privacy? Privacy doesn't come into play on such counts, I'm afraid.
Okay. Pinky Anand giving us the other perspective, and we will continue these debates because we believe that these are the real issues of our times that need to be debated. On News Today, we will continue to hold those in power accountable.